going live in a minute.
Yeah, okay. That's nice.
Good morning, Sumant. I can see that now you've appeared. I can see you now.
Good morning, Sumant. Good to see you.
Morning, Sumant.
Hi, Sumant. Good morning. Vivek, just please organize to see that he's unmuted.
Unmuted. Yes, yes.
Yes, I think now, Sumant, unmute yourself.
Sumanji.
Good morning, sir. Good morning.
Good morning, Sumanji. ACA is very lucky to have you back at ACA.
So I am grateful. I am honored to have been given the opportunity.
Good morning, Sumant.
The honor is always ours, Sumant. Can't be ours ever.
Excuse me for my
You
informal
can't take
dress.
away our honor, okay?
I am on my vacation and I didn't carry any formals.
Doesn't matter.
अच्छा आपका इंतजार था अब आपका इंतजार था तो we will start. Mumta, start now.
जी.
Yes, okay.
Mumta.
Yes, we will begin, dot on time. A very, very good morning. After we celebrated the Lawyers' Day, which was so much in consonance with B.R. Ambedkarji's every thought that he had, not only for the India which was becoming independent then, or had just become independent, but of course, even today, it is so very relevant when we are celebrating 75 years of our independence. I think India has been the ethos of India, the great country that we live in and we belong to. The ethos of this very nation is so very embedded in all our minds that each time that we think of it, we actually get goosebumps. Because it is sometimes we feel that it is beyond timelines, it is beyond the clock that our forefathers and the great visionaries had given us this beautiful canvas called India, in which we paint our dreams and we put in our own perspiration to make it grow further for all our future generations to come. I think when we got insolvency law, all of us, not only as professionals, but as responsible citizenry, looked up to this and we wondered that probably why did we not have this earlier? Though it was mooted for long, very number of years before we got this as well. But better be late than never. And I've always felt that something which may not have happened earlier was probably waiting for its right time to see the dawn of the day. And when we actually got it, we saw that this became such an important law because this law was actually dealing with real money. The economic power behind this law was so humongous and huge that each one actually stopped reading page 3 of the newspapers and went on to see what is being transpiring into the insolvency space in India. And when we started doing this, we also encountered a very important case that our country went through, that is Jet Airways. And when we went through Jet Airways, it threw open a lot of challenges in form of cross-border. And because it was an insolvency law, so we all actually went on to see that how cross-border insolvencies will actually play out if we really want to have coordination and cooperation between 2 or more nations. I'm sure the government of India, as we today see, that they are so cognizant and they are so very live to everything that's happening in the country. And they have always lent their ears, nose, eyes, hands, and legs to whatever, good or bad, that's very indifferent, but to whatever that's happening in the economy. They really pick it up and want to delve on it deep and want to dive deep into it. When they started diving deep, they realized that it's high time now that a specific group should do a deep study on this and come out with a concept paper, a note on this. And that's how we saw so many committees delving on it. And then we saw one committee which was formed by the government of India to find out, to give suggestions and feedback as to what is required in the country so that we can actually either adopt Uncentral mode or we can think a different route altogether. Today, we have come together to actually discuss, understand more, and see what can we suggest more to the government of India, what course corrections further could be actually given in the concept paper that is already there, the rules and regulations. I must say at the outset that part 3, we understand that's part Z, I guess. That's already in the public forum for a long time. And now today we see what in the public forum is the rules and the regulations, the draft rules and regulations which quite emanates from that part said, and some other few other points that which they felt it important to make it complete. So it's now time actually that all of us not only know about this cross-border insolvency, but know it a little deeper, because now this is going to become a reality. In the yesteryears, maybe 2-3 years back, we were just wondering that are we really rightly poised to accept cross-border? But today, I guess there is no question of rightly poised or not. We actually have to embrace it. And when, as human beings, we get to know that now there is no choice, we all pack up our bags, we pick up our running shoes, we tie them hard, and we make sure that we actually learn them hard. And no better people than our esteemed speakers who could have done this for us. I'm very elated to actually welcome Mr. Sumant Batra. He's a name in insolvency. I'm sure he would have been doing much better in earlier years also, and I'm sure he would have been known as an insolvency lawyer, not with the advent of IBC 2016 in India, but even before that, because our country got it in 2016, but other developed nations already had it before. So Sumant, we got to know you more because of the insolvency law in this country, and we are very fortunate to know each other well. And thank you so much for joining in. I just heard that you are in a holiday, but in spite of that, it only shows your commitment to the nation building process.
So thank you so much, Mamta. It's always a pleasure to be able to share whatever little knowledge or information that I've acquired out of my experience. And that's the motto of my life. Always share whatever knowledge you have and not just keep it confined to yourself for benefit. Although I must say that it is a sin to wear anything formal in Goa. It is also a sin to wear a full sleeves in Goa. But I couldn't have appeared in my most casual, so you'll pardon me and you'll bear me for this.
Thank you so much. Thanks once again. So we'll come back to you when your session comes. So please hold on to that. Thank you. I also welcome Madam Vanita Patnaik, who's also an esteemed speaker with us today. She's the Assistant Professor Law from the West Bengal NUJS, National University of Juridical Sciences. Thank you, Vanita, and also thank you so much for joining in this program as a participating organization.
Thank you, Mamta. Thank you so very much. I have to add just one word here.
Yeah,
while you said that about Sumant, that we now know him more because of the 2016 Act. In fact, he was the first person who encouraged me or launched me around the corporate insolvency. And I'm talking this way back, I think in 2005 or 6, he was passing by Calcutta and I'd invited him to our university for a talk. So since then, the insolvency and my role in that has always been, I would contribute it to him, absolutely. And we are very happy, and it's a privilege to be here and to be with you as an organizing as well in the organizing committee.
Thank you so much. Thank you. Sumant, are you saying something?
Yes, I was saying that's very generous and very kind of Anita to say that. I don't think I have any contribution there. I mean, it's just I pointed a finger towards something which I thought was going to be a futuristic law, and she was wise enough to walk that way, is what I would say. Thank you.
Thank you. We also have our esteemed guest of honor today, Professor Dr. Nirmal Kanti Chakrabarti, who is the esteemed Vice Chancellor of the West Bengal National University of Juridical Sciences. But due to his extreme preoccupation that came on at the last moment, he has extended his warm greetings and best wishes to the program. And he's also sent his write-up, which he would like us to read. I'll do that in the course of the program. But very quickly, in his absentia, but I extend my warm greetings to him, and also a big thank you for being agreeing to join our program. This program, which is India Gearing Up for Cross-Border Insolvency, is jointly organized by the Association of Corporate Advisors and Executives. We have CA Vivek Agarwal, who is the president of this association. We have the Center for Financial and Regulatory Governance Studies of the West Bengal NUJS. We have the IBC laws, which we are reading in and day out, very quick with its updates. And now they have started giving one or two very detailed paragraph, exactly what the order is containing. So even during the day, when the program is or when the court is on, we can just see on our Telegram or on our WhatsApp exactly what has happened in whichever courts. So thank you very much to IBC Laws, especially CA Unkar, who's the representative from IBC Laws who has joined in. Insol India, the The term says it all. Thank you so much, Mr. Chandyok, for being here with us and having Install India in this program. We have the NCLT Kolkata Bar Association, which is whose president is Shri S.M. Gupta ji. Thank you, S.M. Gupta ji. We have the International Women's Insolvency and Restructuring Confederation, which is popularly acronymed as IWIRC, the India network, whose chair is Madam Manisha Dheer. Thank you, Manisha ma'am, for joining in. She's also joining in from Delhi. This program is supported by the media partner, which is Sanmark newspaper. That's a very, very largely Hindi daily, which is circulated very heavily in the eastern part of the country and other parts too. And the digital media partner is Governance Now. So thank you to Governance Now. Polumi, if you're there, thank you very much for joining in. And from Sanmark, Neha, if you're there, thank you so much. So I straight away give fiction to the program, and I invite Shri S.M. Gupta ji, the president of NCLT Kolkata Bar, to give his warm welcome remarks. Vivek, could you just see whether he's unmuted?
He's unmuted. Gupta ji?
Gupta ji, आप बोलिए please.
अनम्यूट कर दिया?
Yes, you're unmuted.
अच्छा, ladies and gentlemen, namaskar to everyone. This is a privilege for me that we at NCLT Kolkata Bar Association, every time we join in such programs which are running or which may be coming, and we start the discussions right from the bill or the paper is circulated in our country, because we have a consultative law-making process now. First of all the papers are circulated, then the bill comes after discussion, and then the act is passed. So this consultative law-making process is a democratic way of passing any kind of law, so that the stakeholders can also participate in law-making. Yesterday, I was attending the National Practicing Company Secretaries Convention in Calcutta virtually, and I found that one full session was devoted to IBC law, in which all the panel speakers devoted 50% of their time on cross-border insolvency. And most of them are wondering whether we will follow the law of the UK or USA, and so many other things were discussed. In any case, today we have got wonderful speakers, and I welcome them all on behalf of our NCLT Kolkata Bar Association. Mamta Binani is having so many crowns on her head, and one of the crown is that she is the vice president of our association, founder vice president, and we founded this association with the active help of Mamta Binani. So with these words, I welcome all of you once again. Thank you very much.
Thank you, Gupta ji. It's your support, your hand, and your grand wishes which actually leads us everywhere. Thank you so much for being there. Vivek, would you like to give your opening remarks of the program?
Thank you, ma'am. Thank you, Mamta ji, for organizing this wonderful session on Sunday morning. Good morning to one and all present here. I, Vivek Agarwal, President of Association of Corporate Advisors and Executives, a renowned association of East India, which have made inroads pan-India by virtual programs during COVID-19 and working in becoming your digital learning association. Feel extremely privileged and honored to address all of you in front of our esteemed speakers, Advocate Sumant Batra, insolvency lawyer and a frequent speaker at ACA as well, Ms. Vanita Patnaik ji, Assistant Professor, Law, Director, CFRGS, and our very own CS Advocate Mamta Binani ji, IP and Advocate and past President of ICSI, along with all the participating associations, Chandak ji, Manisha ji, SM Gupta ji, Unga ji. Before the commencement of the deliberation, I would like to introduce ACA, whose founder had put no stones unturned to form an association with motto "Work is Worship." It's the member of the ACA whose combined effort made this association successful. It is always the continuous contribution of our members working to make ACA reach new zenith. ACA is one of the oldest professional body in Kolkata, was established in 1960. Members of ACA has a diverse profile and include professional practitioners, lawyers, CS, corporate executives, entrepreneurs, industrialists, and businessmen. ACA has a strength of 1350 members and has become a premier institution of excellence and learning in the field of accounting, taxation, legal, corporate matters, and finance. ACA program has been addressed by various luminaries like late Jayaprakash Narayanji, late Sri Somnath Chatterjee, Bharat Ratna late Sri Pranab Mukherjee, Honorable former President of India, our Keshrinath Tripathi ji, former Governor of West Bengal, Mr. Arvind Panagaria, then Vice Chairman of Niti Aayog, Amit Mitra ji, and so on. And recently, Sri Arjun Meghwal ji, Honorable Ministry of Parliamentary Affairs, and Sri Bhupendra Yadav ji, the man behind the IBC code, was our chief guest on this topic, insolvency profession and institution in making. Friends, ACA has initiated and established its first annual corporate awards in East India in association with ET, also known as ET Bengal Corporate Awards. We have a state-of-art office in Dalhousie area and recently added an annex office to it. On behalf of the association, I cordially welcome all the speakers to enlighten us on cross-border insolvency. Globalization in India was to make the Indian economy one of the fastest growing economies in the world. An array of reforms was initiated with regard to industrial, trade, social sector to make economy more competitive. It also heralded the integration of Indian economy in the global economy in 1991, and this has led to corporate debtors having assets or creditors in more than one country. The amended code would empower insolvency professionals and creditors to access such assets outside India of corporate debtors, maximizing the value for all the stakeholders. Similarly, foreign creditors to an Indian entity become party to bankruptcy proceeding if the borrower goes bankrupt, and it would also bring more foreign investment in India. So looking forward to an enlightening session. Over to Mamta ji. Thank you, everyone.
Thank you, Vivekji. May I now
Mamta, before you say anything, I take pride in announcing that Association of Corporate Advisors is a 61-year-old organization, as Vivek said, and I was the only company secretary during these years to become the president of this association, except one advocate, Mr. B.P. Khetan. All other, except we two, all other presidents were chartered accountants. So in the this I just wanted to tell you
Thank
that B.P.
Thank you
Khetan
so
was
much.
among the first five. B.P. Khetan was among the first five presidents, and I was, of course, in 2010. Thank you.
May I move on to Madam Dheer? Would you like to give your introductory remarks?
I'll just take a few minutes. I won't come between the speakers. A very, very good morning to my esteemed speakers and my honored guests. It's indeed a privilege to speak at such a forum. And I thank Mamta for inviting me to speak at this forum. I'll just take 2 minutes to introduce what iWork is. iWork is a body of women professionals in insolvency. Of course, now includes men. We've been functioning for the last 30 years and we have a presence in 21 countries and have 39 networks. And I very proudly say that Mamta was in fact the winner of the award this year. iWork winner of the award this year. And it is indeed a privilege to speak at this forum. I'll just take 2 minutes about cross-border insolvency. Well, cross-border insolvency has been a very, very important part of the IBC code ever since it was introduced. And with the coming of the cross-border laws in 2018, and now the fact that public objections, suggestions have been invited on these issues, on specific issues of what is the access, whether foreign insolvency professionals and financial creditors will have access to the domestic courts and recognized by the domestic courts, whether the foreign ancillary proceedings are abroad or will be India, would also be a very, very important part of determination by the domestic courts, and cooperation, coordination, and the very fact that the public policy says that in case any of these, if any of these are against the public policy, then the courts have the right to actually reject it. The two very important issues again, which has become part of this debate, is that they have excluded the financial services and of course the pre-pack insolvencies, which are at a very nascent stage from cross-border insolvency. With that, I would like to hand over to speakers to elaborate on these issues. And the only thing I can say that Jet Airways, one of the landmark cases where the Indian courts tried to integrate a very uniform insolvency system and debated whether the administrator appointed by the Netherlands court would be ancillary or would be the center of main interest. And of course, now all this will become history once we have a very set cross-border insolvency regime in place. Thank you, Mamta, so much.
Thank you. Thank you, Madam Dean. May I now request Mr. Chandyok to give a brief about maybe cross-border insolvency, or because he's been into the thick and thin of things for so long, I'm sure he would have his say for the program and for the subject.
Thank you, Mamta. Thank you so much. Let me first say good morning to everybody and say it's a great time that we are all joining hands. And I always been saying that everywhere there has to be a collective effort. Let me start with Insol India. Well, when we started Insol India, and Sumant fortunately for me is here, who actually was the person who also laid the foundation stone for it. There was nothing called insolvency in this country. We started Insol India. We went not only in India, but even went abroad to do conferences, only to look at the principles, see what are the developments in the developing world and the developed world. And all this time was taken till we ended in 2016, that we got this IBC in place. Insol India, right from day one, had an honorable judge, Justice Serene started. Then we had my Lord Justice Sikri, who is now the judge of the retired judge from the Supreme Court, but still a judge at the Singapore Commercial Court. Justice Sanjay Kishan Kaul, who is the judge today at the Supreme Court of India. So all these stalwarts were there along with Sumant, who came as the Secretary General of Insol India and went to Intron International as the president. So I think the great honor for Insol India and India that Sumant was elected the president of Insol International. And that's where the whole system starts. An equally proud moment for Insol India that after Mamta has been announced, she's part of the executive. And also we have Dinkar, who has now been made a part of the Asia Pacific, so that Insol India gets these credits through these luminaries, all these stalwarts who have been putting their might into the insolvency regime of this country. And if I can say with sense of pride, everybody in Insol India, whosoever at whatever stage they were, they contributed their might to see that we can bring a regime till we brought 2016. We have seen changes from 2016. In fact, that's the only legislation, or if I can say a subordinate legislation, which has undergone so much of changes ever since it was joined. Otherwise, if you see, just to give you a very small example, in 2002, an amendment was made in Section 89 of the Code of Civil Procedure to bring mediation into it. In 2010, the Supreme Court said you need to amend it, but we are in 2021, nobody has looked at it. But this was one legislation where the change of times when the need was arise, either the IBBI or the legislature itself decided to amend it. Now, as we saw, we already had in the statute two provisions of 234 and 235, which did not actually lay down the correct position, because at that time we thought insolvency must come in. The first question was whether we should bring domestic corporate insolvency into it, because a lot of things were happening at that time. Therefore, at that time, these two provisions were added. But now the time, as Mamta has rightly said, that time has come when we are looking at cross-border situation. We need to look at them because there is a necessity today with so many interconnected investments going up and down. In fact, to be fair to I'm sure each one of you know about it, but I thought I must bring it on part of me that today India's investment in UK is much more than UK's investment in India. So our assets are many more there. So similarly, in many other parts of the world, India has assets. There are many parts of the world where foreign companies are investing into India. We brought that concept that when we bring some investment into the country, then initially we all thought we should give them an exit route. And that exit route was after giving them a minimum money that was turned down, and the court struck them down. So therefore, we now thought that what is the exit? A man has come into investment, he wants to go back. The exit was only to come back into an insolvency regime where you're restructuring the company. But having said that, I think there's 2015 report, 2018 report, the draft bills, the Uncentral laws, all need to be debated, in fact, clause by clause to see how do we fit into the regime? Because we have different circumstances. In fact, if you see the investments going from north to south, even within this country, there are differences. And most important is, still most business houses are family-run concerns. Therefore, we need to bring that concept into it. But Sumant would probably in his own turn would put me down or whatever he wants to say to me. But I am looking at actually a resolution plan. Which resolution plan, maybe I am giving more chips of money into it. But Sumant, as an expert there too, is entitled to turn it around. I think the plan with Sumant there should be passed, not because he's brought some money into it. Therefore, that qualification into cross-border is more important today. We need to build relationships. After all, and that is why the government is today considering, in fact, yesterday only at another webinar, speaking on that, I said that to Vinitaji before we started this function, that today mediation, Sumant will remember the first report that we submitted on personal insolvency. We said mediation was a process that we must look at. Because after all, it's a repayment program that we are looking there. We are not looking at, in that sense, of the resolution professionals coming for making something else. So if that is the situation, then even today, and I am very happy to place before this August gathering, that in this pandemic, at least 20 matters have been referred by people themselves to us, which was either a dispute between two resolution applicants or dispute between the management and the creditors, and we have been able to resolve them and put the mediation position. And this is nothing to do with the Reserve Bank of India circular or for that matter, Section 709 of the IBC. Therefore, these situations have come where we all professionals will have to contribute and contribute to the harmony, peace, which ultimately leads to economic position. Because ultimately it's the nation that needs. You see those first 12 cases that we have seen in insolvency. Those, for example, a steel plant can't be built for over 10 years with the money that we have. But with the restructuring done, that asset is available for the use of the country today. We saw in pandemic, the steel plant gave us oxygen. They diverted that oxygen to us. Now, these are collaborative efforts. Therefore, even with respect to cross-border, we need to first look at the situations, the relationships, the bilateral treaties. And I must place it on record, a very dear friend of Sumant and me, who is a judge of the Supreme Court of Singapore, brought rules within the judicial system, which will recognize to see that one judge sitting in London does not pass an inconsistent order sitting in Singapore or India. Therefore, this actually is nothing else but collaboration, whether it's a judiciary, whether it is somebody else. And all colloquiums held in Insol have been seen to it. We are asking the honorable judges to contribute what should be the role of the insolvency courts in order to see the bring insolvency back. Therefore, corporate insolvency position on cross-border is an important aspect. It's something very to be looked at very seriously. And I'm very happy that so many papers have been put, so many things have been put in the public domain. The only request, and I'm making that humble request in this August gathering, that the Government of India and the Ministry of Corporate Affairs, I'm sure they will, but I'm only making a humble suggestion that all this must be collated and debated before they actually put the law and the rules in place, because that will help us to do so. So many things, Uncentral model laws have been in place for decades today, but India has its own difficulty. We saw Uncentral in arbitration. We did not adopt Uncentral law. We modified it because our Indian conditions changed that part. Therefore, in India, Uncentral law could be the best basis for us. Yes, no doubt about it. We must look at that, but we'll need a lot of amendments in many other statutes. We need a lot of amendments in recognition of orders. We need amendments with respect to, in fact, I know there is a mirror order situation that we brought in. The concept was brought in orders from various countries as a mirror order. And we lately, 2 months ago, if you all have seen, the Supreme Court has returned its own judgment. It has set aside its own judgment because it found in Kenya that mirror order was of no consequence because it was not recognized. And therefore, it was misled in passing that judgment. Now, therefore, we should be careful, especially in relation to cross-border, because some of the countries are Commonwealth countries, some of the countries are common law countries, some of the countries are civil law countries. Therefore, the system is I think some remark was made whether we'll adopt UK or USA. No, I think India is unique. India is an emerging economy today. It is looking at the leadership of economy, not only in the Southeast Asia, but in the world. If that is what the aim is, then I must bring laws which cater to that need. And that need is that we need to debate it much more, right from this threshold to bring it up and then see that how best we can do. Because of course, it will be challenged, they will be done. In fact, I wanted to raise that. I didn't want to raise in this issue here, but it has come in. The Bar Council has already written a communication to me to say that how will, if your Indians are not allowed to appear in reciprocating country, how are you allowing in a cross-border insolvency? Foreign creditor can come, he can file a application. I mean, we are not saying that he can't invoke that jurisdiction, but we are looking at foreign professionals today. And in fact, there's a petition filed today in the High Court of Delhi where people are challenging even the presence of other people in the NCLT and NCLT. Therefore, I think we need to do away with all this. We need to bring a collaborative effort. Everybody has to contribute to this, their might. And because ultimately the aim is one, how do we restructure this country? How do we bring more economic wealth to this country? How do we bring more investors into this country? How do we attract more industrialists into this country? So that we should leave a legacy behind for our youngsters who will then remember us for bringing all this. And I said this to Vinitaji earlier, that it is this legacy that is important today. I don't think in my time I ever even heard the name of insolvency when I was in law school. But today, yes, law school is teaching that. A Companies Act was only, I think, 3 questions in my entire corporate paper in the law faculty. But today's situation has changed. But look at the Companies Act 2013 itself has made the changes. Therefore, we need to build a system. And that system must be, both we have responsibility to the people of this nation to ensure what we do. And Mamtaji said we celebrated the Lawyers' Day. In fact, Dr. Rajinder Prasad's day was 3rd December. We celebrated it in Delhi as the Bar Association of India, because he was the one who in fact said, what should be the government as Praja wants it? And we turned it around to say today, what should be the Praja? Praja should elect that whom they wanted today. Therefore, those examples that those leaders gave us are still relevant for us. Therefore, today in this August gathering, I'm sure Sumant is going to put a great light into what we are looking at. Vinitaji, the Honorable Professor will also lend academic knowledge to it. And I'm finding today so many academicians participating in our situations so that we all can understand not only the aspect of a lawyer arguing it or a company secretary arguing it in NCLT, or for that matter, a chartered accountant, but also from an academician point of view, what should all it contain so that it will stand the test of times. Times ahead are difficult, no doubt, but are they fascinating? Absolutely fascinating. Today is time that the world needs to look at each other. We need to hold our hands instead of doing what we are doing today. In fact, we have started today looking at, as I said earlier, we have started looking at peer mediation today. We have gone to now a situation where we are looking at mediation in the universities today. In fact, the compulsory subject has been made, though somewhere it is optional or anything. But all that is the purpose of word mediation is not to look at a structured situation. The purpose is how I and you can sit down and resolve something with only one end, and that end is how can I bring this asset, this economic situation, how can I bring disparities, everything less, conflicts bringing to an end. And when we can do that, restructuring will automatically come back. The economic challenge that we have, we'll always meet it. And I'm sure time is not far when we'll meet these challenges with all these professionals telling us, guiding us. I'm sure day is not far when India will be on the top as the economic power. We, in fact, today, to be honest, we're very happy to see that Swiss ribbon judgment of the Supreme Court was sought from me, from a lawyer in the United States. There could be no better fascinating situation than this to a lawyer in the United States seeking a judgment in Indian court. And though, of course, we are poles apart so far as we in Pakistan is concerned, but I don't think there's any 3 months or 4 months when I don't get a lawyer asking me, what did your Supreme Court or the High Court say with respect to that? And in fact, the latest one was with respect to insurance, medical insurance in pandemic for lawyers, with the Delhi High Court judgment passed. So he wanted that judgment because he was fighting something in the Lahore High Court. So these are instances where cooperation is the only theme that I look at. Therefore, all these papers we need to look at. Report of 2015 was at a different aspects altogether. 2018 changed that purpose. We have now got rules in place, draft rules in place, as Mamta said earlier. So we need to look at them to see how best they are suited for our purpose. Make those amendments, make those suggestions to the government, and I'm sure they'll be looked at when the final legislation comes in. Thank you very much. Thanks, everybody.
Thank you so much, Chanjok sir. A very well set tone that you gave us. I'm sure we all are actually deeply pondering on this, because we are left with nothing else to actually look at it with our lenses, because this is going to affect all of us as a profession and to the country at large. I'll not do much ado, because we need to also now listen to Mr. Batra. Sumant, there are so many issues doing the rounds in the country. Now we are also seeing jurisprudence emerging on cross-border insolvency. We have also seen a very recent case law in the Cuttack bench of adjudicating authority, whether a foreign award is sufficient to actually initiate insolvency proceedings under Section 9 of the Insolvency and the Bankruptcy Code. So there are so many other judgments which came in by the Jet Airways case and even otherwise before that. So definitely, the adjudicating authority is confronted with issues of cross-border, and in their own limited manner, they are trying to lend to this space. You have been into this from day zero. I don't want to say day one, but day zero, because your book that you came out with in the beginning actually deals with this cross-border quite in details, as I was going through it a few days back also. So no one better than you can actually take us through. And may I actually request you to give yourself an hour, because that 1 hour will be quite vital to each one of us. And our esteemed participants, it's actually more than 200, if I may say so, because we are also live on YouTube. Not that numbers matter, but what I wanted to say is that so many of us have got together on this Sunday morning, where all the wives of the spouses and otherwise the husbands of the spouses must be shouting why you have actually lent my time to others. So let us give them a big bonanza by letting them understand the cross-border insolvency well through you. Over to you, Mr. Batra.
Oh, thank you. Thank you so much, Mamta. Before I start, just a couple of housekeeping comments that I wanted to make. One, that I wanted to mention that I'm sitting on an island, and if the power goes away, I don't have any alternate or a backup. So just bear with me, let Vanita start, and I'll join back as soon as the power comes, if at all it goes. I'm praying and hoping it doesn't. And the second one is that I would use a few slides as well on the way, although I'm not known for using slides, but because I speak my mind, I'd rather speak from a more macro point of view and more practical point of view, rather than make it very scholarly or academic, which is something which I'll leave Vanita to touch upon. Not saying that she cannot be scholarly. I mean, she will be obviously very scholarly as well. But I just thought these are some of the things that I want to mention. I don't really want to get into the nuts and bolts of the law as much, because I'm sure everyone has read it and would have their views on that. Now, but before I start, I just want to mention, and I know we are being recorded, but it's all right. I mean, I will still continue to be as candid as I have always been. And let me also, in fact, start from something which might be a little disturbing for some of the people who might be listening, is that, this is something, it's quite ironical that, I'm speaking on cross-border insolvency law 16 years later than we had first raised it with the government of India. 16 years it has taken as a wait. And I have been a sort of a missionary, and I'll fill you in that also for 3 minutes to give you the context why I'm calling it as ironical. Because today, I don't feel the same level of excitement about the cross-border insolvency law being introduced. And it is not because of having lost hope. It is because I feel we live in very different times today. We are going through very different times today. And I'm not too sure whether the cross-border insolvency law that is being introduced, one, whether it's the right time for that, and two, whether it is being brought in in the right form. And I am also someone who, I would like to make it very clear, have been advocating for 16 years that not a single comma or full stop should be changed from the Uncentral model law. And actually, there is no change in this legislation, but I feel that given what the world has gone through over the last 5 years and what we are expecting to happen in the next 5 years, and I'm not talking about pandemic at all, I'm talking about other developments which I'll come to in a moment. I really feel that we needed to probably look at the cross-border regime from a very different prism than just the Uncentral model law. And I'll explain that all in a bit of a moment. I don't want to be sounding as disruptive or pessimistic or propagating that I'm not in favor of the cross-border insolvency law, but I do feel that there are certain dimensions of the cross-border insolvency law that need to be taken into account. But before I come to that, let me just tell you about the 16 years thing first. You know, it was in as far back in 2005 or 2006 when when J.J. Irani committee report came on the revamp of the company law. A year before that, some of us had met the then Honorable Prime Minister Dr. Manmohan Singh and mentioned that we should include insolvency law rehash also as a part of the company law rehash that was being contemplated. There was a very senior bureaucrat sitting in that meeting who said, "What are you talking? The ink on the earlier regime, our 2001 amendment has not dried, and you want to talk about the other one. You want to talk about an amendment already." Because I told him that, you know, the 2001 amendment is based on almost 10 to 15 years dated thought process. The world has moved since then, and we need to think futuristic. Dr. Manmohan Singh, being an economist and someone who has worked, as you know, IMF, World Bank, very deep understanding, agreed, and he requested the corporate law minister, Mr. Premchand Gupta, to include in the scope of J.J. Irani committee the insolvency law as well. And incidentally, I was then requested to come on the committee and help with that. As a part of the recommendations of the Irani committee and the draft bill that was presented to the parliament, it was recommended that the cross-border insolvencies should be added as a schedule to the company's amendment bill. And why not as an integral part of the company's bill in terms of substantive provisions, but only as a schedule? The reason for that was, and rightly so, that the regime of insolvency law, domestic insolvency law, was still going through an upheaval. We didn't really have a stable insolvency law, domestic insolvency law. We needed to have our feet firmly on the ground as far as the domestic law is concerned before we could introduce the cross-border insolvency law. And therefore we thought, let it come in as a part of the schedule, so that as and when, if at all, any cases come before the court involving cross-border issues, at least some guidance can be sought from that in a statutory form. So, and it's a pity that in the UPA 1, the bill did not go through because of the Satyam issue. JPC referred it back to the government, and government had to reintroduce it in the UPA 2 terms. And we all know that UPA 2 terms did not pass it, or could not pass it, till the fag end of the term of the Lok Sabha in 2013 or end, or 2014 beginning, just before the election, but it never got notified by the parliament, by the president, I beg your pardon. And then, of course, we all know that NDA 1 formed the government under the Prime Minister, Mr. Modi, and they decided to introduce a brand new regime of insolvency, and insolvency and bankruptcy law reforms committee was set up. Bankruptcy law reforms committee was set up. Now, what is strange is that the bankruptcy law reforms committee also thought the same, even 10 to 10 years down the line, that we should wait for the IBC, which is sought to be introduced, to stabilize, and let's just get a feel of that, and then we will talk about it. And also, they were under tremendous pressure to introduce it in less than 1 year. and they didn't have the luxury of time where they could apply their minds on the cross-border insolvency law. And it is quite apparent, with no offense meant to any member of the committee, even the personal insolvency law did not get that kind of attention. And we all know, as we read its quality and how the amendments have been taking place and will continue to take place in order to provide it the kind of sophistication it needs in terms of the language. Now, incidentally, the Joint Parliamentary Committee in its paragraph stated, and I want to mention that in a moment. I know that I don't want to get into the slides part, but I'll just share this slide for a moment. I wonder whether you can see this slide.
Yeah,
Yes,
we can
yes,
see the
sir.
slide, sir.
Okay.
Okay,
Absolutely.
very well.
Perfect.
So now if you see, thank you. Now I just want to go to the previous one. Sorry, just 1 second. Just give me a second here. I'm trying to set up. Just trying to find. Yes. Now, sorry. This is the paragraph. Exact paragraph quoted from the Joint Parliamentary Committee in 2016, before the bill was passed. The code at present does not explicitly deal with the issues and text related to cross-border insolvency. However, given that many corporate transactions and businesses today involve an international and cross-border element, this is what Mr. Chandyok alluded to in his comments. The implications of cross-border insolvency cannot be ignored for too long if India is to have a comprehensive and long-lasting insolvency law as the code aims to achieve. Not incorporating, this is very important, not incorporating this will lead to an incomplete code. Now, when the parliament of the country, the Joint Parliamentary Committee says so, it of course is a very clear mandate that you need to bring it. Now, again, as I said, the government was under tremendous pressure at that point in time. They didn't want to go back to the committee. It would have taken long, fair enough. And that's why Mr. Jaitley, being as eloquent he was and as a clever lawyer and a parliamentarian and a politician he was able to duck this issue in a very sophisticated way. And I'm not treating it as a criticism, but as an art, I'm saying, by telling the Joint Parliamentary Committee and the Parliament that we will address the issue for the time being by providing Section 234 and 235 in that code, which will provide us the enabling provision, and from that to have an enabling framework for a bilateral arrangement, whereby actually then you could actually address the issues of cross-border insolvency. We all know that. But 234 and 235 was never introduced. It was never implemented, if I may say. And I have to take a part of the criticism or the credit, whatever way you may look at it. Because I wrote a very strong note and I also mentioned it in one of the meetings. And perhaps Mr. Chandyok was also there in an IBBI meeting where the secretary was also there and some very senior people from the government were there. And I said, 234 and 235 would be disastrous. You can never have a uniform agreement with 50 countries. Bilateral agreements are based on bilateral issues. You can't have a model agreement which every country will do. Number one, there'll be a lot of give and takes when you start talking to countries. As Mr. Chandyok also mentioned, the issue of why my professional should not be allowed to participate in your country, why yours should not be allowed in my country, what should be the terms. We all know that WTO issues have been happening for a very long time, where this issue of allowing professionals to participate in each other's country systems has led to a lot of debate, where some people want the agriculture sector to be opened by India before they allow professionals to come. And we always said largely it was never going to happen. But any which ways, the fact is that we did not have the cross-border insolvency law for the last almost 5 years. And we have, unfortunately, if I may use the expression, suffered greatly in the last 5 years because the first about 30 cases that came into insolvency, were pushed into insolvency, included very large conglomerates. And many of those had cross-border businesses and acquired in the last 50-20 years by Indian entities, many of them in distress, many of them actually doing well, but nevertheless having a tremendous amount of value. But we were deprived because of the absence of cross-border insolvency law to claw back that value. The resolution applicant that put in plans gave almost zero value to these assets because they said there's no way by which they'll be able to retrieve the value, recover the value, or be able to even give a contingent value to that. Be it Amtech, be it Videocon, be it a large number of other companies, SR, we all know, had businesses, huge businesses, some of them flourishing. But they all were sort of, there was an iron wall between them and the Indian entity. And as a result of that, the Indian lenders were deprived of those, even though those assets were partly created out of the wealth of the Indian entity. And therefore, we kept telling the government that please do something about it. In fact, in 2017, you'll be surprised, in 2017, Mr. Vishwanathan and I sat down and drafted a bill of cross-border insolvency, gave it to Mr. Jaitley, who was kind enough to forward it to the Secretary, Ministry of Corporate Affairs, rather than Secretary, Minister of Corporate Affairs. Mr. Chindyok would remember that we held a round table, a series of round tables with stakeholders to discuss that draft and gave our comments also as market participants to the government, but it didn't see any movement. Without naming one senior official who I had met, I would say that when I said, why no sense of urgency? The response was that we fear that this would benefit foreign companies more than Indian companies. There were other comments also made, but I don't want to go into that. I particularly chose to mention that because Mr. Chindyok very rightly gave the example of UK. As to today, where India has more investments in UK than UK traditionally had. UK was always the fourth largest or the fifth largest investor in India. After US, Japan, Singapore, then probably UK. I'm talking about 15 years back after the economy was opened globally, 1990s, beginning through the first 1.5 decade. Now, the world has changed. Not only that Indian companies have investments abroad and would benefit equally from this law, I see no harm if the companies abroad also benefit, because if you will not provide a level playing field, you will never have a fair game. And insolvency law is about a fair game. This is not adversarial proceeding. It is not an adversarial process. It is a process which is based on preserving the rights of lenders, whether located in India or overseas. Those rights that have come into existence prior to the invocation of insolvency, commencement of insolvency. That is the fundamental principle that marries insolvency law and secure transactions regime. You can't distort that. Yes, of course, they take hits. They obviously go through a churn in the insolvency process, but you have to appreciate and recognize the secure transactions, superiority of charges, hierarchy of charges whether I've secured creditors abroad or in India, any part of the world. So where is the problem? But any which ways, finally, we did have Insolvency Law Committee making a report in 2018. Fortunately, the Insolvency Law Committee recommended the same draft as a part of its report, draft bill, which we had given with 2 changes, and one of which we were fine with, and the other we weren't, and I am not even till date. One which I'm fine with is the central government keeping with itself the ability to exclude any country from the list to which the cross-border insolvency law would not apply. Fair enough. Why would you want to give the benefit to the lenders coming from an unfriendly country or a hostile country? We wouldn't. And it's all right, therefore, to keep that power with the with the executive rather than give it to the judiciary. Parliament can always, by subordinate legislation, allow the central government to make rules on that, and by subordinate legislation decide whether a particular country should be someone which we should shake hands with as far as the insolvency regime is concerned or not. But the second part, which I have a bit of a difficulty, was the reluctance and hesitation that comes in through the reciprocal provision. Now, we all know, those who have read the cross-border insolvency law in its history, that out of about 51 countries, I don't have the exact numbers now, but I think it's about 51 or around that, only one country or maybe 2 countries have provided a reciprocal provision on the applicability, and one of them is, of course, South Africa. And the second probably is the most, is a less significant country, but I could be wrong. Maybe there's a third one as well, but I know from the significant countries or significant economies from that point of view, South Africa is the only one. And South Africa itself, and in fact, the insolvency community from that country feels itself that why did our country have to do this? A shame, because it would defeat the very purpose of the cross-border insolvency law. And it has demonstrated in that country not a single cross-border insolvency petition has been filed. Even though the world has matured in the last 20 or almost 2.5 decades since the cross-border insolvency law has been in place, US being the first country to adopt it by introducing Chapter 15. And US is known that when it comes to international protocols, they are the last ones. But they did it for the first time as amongst the first 4 which introduced Chapter 15 as a framework in the insolvency with the bankruptcy code. The point I'm making is that while everything was there, only one point, which is a significant point, this was done. And second, also on the COMI, there was again a hesitation, a degree of suspicion. Therefore, it was said that central government will decide from time to time, and on the center of main interest issue, we will leave it for the NCLTs to determine. And I thought that was again a sign of hesitation. But I'm glad that the 2020 report has suggested that should be done away with. Although of course that probably may not have been the mandate, of that committee, but they've done so, and I hope that once the comments of the public are appreciated, that will be done away with. Now, why I am saying on the COMI part, I'll come to when I discuss the COMI provisions a little bit more in detail. Now, with this background, you'll appreciate, or must be wondering, in fact, in the first place, why did I say that when we have shown so much of enthusiasm in the last 15 years to have this law in place, why now say that perhaps we should wait, or if not wait, then maybe have it in a different avatar? I'll tell you why. You see, when the if you see the history of the progress of insolvency law, although we've seen now 40 years of regime, insolvency, modern insolvency framework, 70s when bankruptcy code was amended by US, that is where when we can safely say the modernization of insolvency law began. Although the seeds of that were sown even as far back as in the 1930s, when soon after the Great Depression, some modifications were made in the insolvency law by US, but the actual modernization started in 1970s. And then, of course, followed by the Cork Committee report in UK when the US introduced this administrative regime. Now, if you see the history of insolvency law, you'll see that every 10 to 15 decades, the law evolved very significantly. Not that the evolution is not a constant exercise, it happens almost every single week. We see something new happening because it's a very dynamic law and it has to keep pace with the economics of any country of the globe. It happens as the business becomes more sophisticated, like the cryptocurrencies are being introduced today. So we are all wondering, how do you deal with cryptocurrencies in an insolvency? How do you deal with the insolvency of a company which trades in cryptocurrencies? I mean, these are instances that I'm giving where constantly you are on your feet thinking about how insolvency law will deal with this, that. Now, in 10, 15 years, a lot more happens. The last major exercise that took place, or every time, if I may say the major, I'm talking about now the major ones, real major ones, happen around an economic financial crisis or an event which you could call as a war. So if you go back to the Great Depression, if you go back to the Second World War, then you go back to such other events. And in the more recent history, I would say the Asian financial crisis of the 90s and the Lehman Brothers triggered crisis in the late 2000s. Asian financial crisis brought in a paradigm shift in the insolvency thinking, where we moved from a traditional way of court-based insolvency to out-of-court restructuring. That is what happened when Asia Pulp and Paper happened. If you see Malaysia, Thailand, Singapore, and Korea all introduced asset reconstruction companies. All of them introduced state-owned asset reconstruction companies. Some worked well, some didn't. But then many countries followed, and we had introduced in India the ARCs. We've seen in Brazil, Chile, Eastern European countries. The whole landscape of insolvency changed. And also the importance of cross-border insolvency, because Asia Pulp Picture sent tremors around the world because there were global investments in that company from a trading point of view and investment point of view. So cross-border suddenly came on the surface as a very important law. And suddenly from 4 or 5 countries it became to 30, 35 and 40 countries adopting the Uncentral model. Lehman Brothers again signified the importance of insolvency in non-banking non-banking finance companies or financial companies, if I may say. Not necessarily banks only, but banking also. That's where the focus shifted. And also the focus shifted on the importance of various sophisticated instruments which come in as an investment, with which you need to deal with in an insolvency. Now, all this attention is paid over a period of time. My understanding is that today, after Lehman Brothers, perhaps a little too early in the life span of an insolvency system, we are going through, or we are sitting at the brink of an upheaval. Now, that upheaval is not a financial crisis. It may not be a war, but it is certainly something that is based on geopolitical changes that have been happening over the last 5 to 7 years. Starting with Brexit. Now, Brexit was a major event that we have seen in the modern history, where when it was decided that British will exit from European Union. And obviously it created a lot of turmoil in the European region and of course in the United Kingdom. And we are still going through the aftermath of that. But from an insolvency point of view, while there was an exercise of integration and cohesion that was taking place, that suddenly saw a disruption. And there were two outcomes of that. And this is something which academics like Vanita would be probably examining it more carefully than I as a practitioner. I am only a viewer, a ringside viewer, if I may say, but if I may, my assessment is there are two outcomes of that. One is that most economies today, from that period onwards, are beginning to, and this has led to a geopolitical scenario, becoming inward looking. While we were talking of globalization, outward looking till then, even from 2014 onwards, the narrative in the country has been inward looking. What self-reliance, America first, India first, that kind of narrative has been happening. And because of Brexit, while it was considered to be the most popular hub for creditor and control regime, and most European countries flocked to UK in the event of an insolvency in their countries, chose that as a jurisdiction. Often UK being accused of, or those companies being accused of forum shopping. But the fact is that credit and control regime, the center of gravity was in UK. That center of gravity disintegrated with the Brexit. Europe decided we will not go to UK anymore. Now, Singapore, a very smart team, thought that somewhere the center of gravity has to be, you can't have a system where there is no center of gravity. They decided to create a system. They tried to build an infrastructure where the center of gravity was towards that. I'll pause that for a moment and moving to another point, but I'll connect the dots in a moment. Now, when the disintegration happened, and we saw that other countries were now eyeing the space traditionally occupied by UK, something which I am very sure India should also aspire to, and will surely, once we've sort of attained a little bit more stability in the IBC, you will find, and I'm telling you what is happening, is that lines between the debtor in possession law and creditor and control regime are getting blurred. The world is no longer going to be compartmentalized in these two tight compartments. And that is for the reason that I am coming to the geopolitical part, because the traditional way of insolvency of being two options only, but controlled by UK and US on two different ends, is no longer something a large number of the economies are willing to subscribe to. A lot of economies have become very strong in their own rights, independent in their own rights, are not dependent on US anymore. They don't see as US as the same superpower as earlier, nor does the UK command the same kind of aura as a head of the Commonwealth countries, and I'm not a politician, I'm not a political person, I'm not an economist also, but I'm taking some liberties of saying something on what I believe in my little intelligence is rational enough as an observer of political developments. When that happens, countries become strong in their own right. They choose the system which suits them, their domestic requirement the most. With whatever changes, they don't want to be seen as replicating the other laws. So the second dot, I'll connect in a moment. The third is the trade tariff war. You've seen in the last 5 years the frictions around the world on trade tariff and how that has impacted the way the trade is done globally. You know that when Prime Minister and Presidents of two largest democracies meet and they discuss how a motorcycle manufacturer of US and India should be priced, the trade tariff on that. And there are strong positions taken that which lead to diplomatic tensions. That is the scale of the undercurrents that develop in trade tariff when people take positions, and when you do trade, it leads to cost. You move from one country, you start trading with another country. You shift your economic headquarters from one to the other. You start routing your imports and export in a different way. Policies change. When these kind of policies are changing globally, obviously it is bound to have an impact on how you view your insolvency law and how is this going to impact that. The fourth dot, and then I'll connect all of them in the next 5 minutes, is the ensuing, and I'm using a strong expression which probably nobody in the media will use, but I can take the liberty, is the ensuing Cold War. We don't call it as a Cold War anymore because it's probably a bit dated. Cold War was always seen in the context of Russia and US, the communist world and the free market capitalist world. We've gone through that in the 60s, 70s, we all know that, from James Bond movies to everything. But we are going through the same thing as a world today. Nobody can call it a Cold War because I'm sure the economists are looking for a more innovative and interesting and a catchy word for that. It will emerge. The students of history will write it. When I say students, not really students who study history, but I'm the scholars and economists. I'm sure in some time to come, you'll find a word coined for that. So I don't want to I don't want to take away from them by calling it only something which I might consider as the right word. But the fact is that today there are undercurrent of tensions between two very large economies of the world. I don't even need to name them. We all understand which these two economies are, which is having a lot of fallout. And one of them we are also not very friendly with. And a lot of US businesses are pulling out of that economy because of the uncertainty, because of the tensions, which got aggravated during the COVID times. But I can tell you, COVID had nothing to do with that. COVID only became a medium. They were persisting for quite some time. This is more to do with geopolitical developments where a particular economy in a country is trying to assert itself globally, politically, economically, militarily, and from a soft power point of view also. And when that is happening, obviously there is a lot of permutation and combination happening in the background in terms of where one should invest, how one must invest, what is the political risk and cost and capital of investing in a country, and whether India is an alternate for those countries. And if India is an alternate to those countries, then does the insolvency law suit them or not? Because they come from a different culture. And if I am introducing to them, if I'm offering them creditor and control regime, well, they will say, why not the debtor negotiation regime? What's wrong with that? Right? If I am coming from a culture I was mentioning earlier in my comment that I am wearing full sleeves in Goa. If I go to the beach wearing my suit, they will call me crazy. Isn't it? You expect in Rome to do in Rome what the Romans do. So if a US multinational corporation is coming to India, they would say, how do you expect that a one operational creditor for a $500 billion company default, which is disputed, files a petition, and they just say, oh, look, in my view, it is admitted debt, and therefore I am ordering the insolvency of a conglomerate of $500 billion, even though the other lenders are absolutely happy getting their money. And the management goes out, and the promoters can't even put in a plan for that company, right? It's a cultural shock to them. I'm not criticizing Section 29A. We did it in the circumstances of our country. Now, let's connect these dots. Now, if you see the scale and might and magnitude of what is happening, has been happening, when these dots get connected at the policy level, a lot of things are in the pipeline. Singapore has been thinking ahead of their times. They have been in the last 3-4 years introducing a lot of changes. So they have now introduced a regime where you can have a debtor in possession regime or a creditor in control regime in the same country. Let the lenders decide. They also have a cross-border insolvency. They are offering a best package. So whether you come from US or UK, South Korea, Japan, Australia, New Zealand, India, we are offering you a bouquet. It is no longer that I, being an ex-Commonwealth country or a current Commonwealth country, I will only have a common law regime. That's not the world is going to be anymore about that. Has that thinking, or does that thinking need to go into what we are doing today? Now, in the context of cross-border insolvency law, if you see the experience that has gone into this in the last 25 years, analyze the various judgments, there's a lot of learning, all for the good, all for learnings for making it more functional, more efficient. And I'm so glad I've seen this for the first time in the legislative consultative process of this country, where in the note that has been put in the public domain by the Ministry of Corporate Affairs, and I'm really, really very, very, very appreciative of the person who drafted that note, or the persons who drafted that note, where they candidly bring out that judgment in that note, which has, to some extent from UK, caused a dent in the cross-border insolvency law, and as to how we need to address that. I also believe that the Uncentral, it will not be as ahead in time, maybe 3 years from now, when Uncentral Working Group 5 will meet again to discuss what we need to do with the cross-border insolvency law, given the developments of the last 4 or 5 years. Something that we should be doing it. And I'm sure I'm not taking away from the committee's ILC, or I'm not taking away from this subcommittee or committee that was set up by the Ministry of Corporate Affairs of the report, which has committed the report. It's a wonderful report, and it's commendable. I mean, they all deserve a pat at the back, and all of them I know personally, very, very, very credible people, very, very intelligent people, and very, very knowledgeable people. And although none of them picked up the phone to speak with me on this, but I'm sure, but it was just accidental. But the point is that we need to apply all these factors and see whether in the cross-border insolvency regime, in the cooperation regime, in the recognition relief regime, in the reliefs and concessions reliefs regime, is there any tweak that needs to be given? I am talking about the substantive provisions of the legislative provisions. I'm not talking about the rules and regulations. That we can amend at any one time. These are subordinate legislations. Now, this was the context in which I'm sorry, I have taken nearly 35 to 40 minutes of my time. But I needed to ventilate that. I needed to because because I, being an observant of developments around the world, I do believe they have a bearing, and we need to be mindful of those as well. In particular, also because since the 2018 report, 2.5 years have passed, and it might be a good idea to visit it. I can understand the urgency and the pressure on the government because of the standing committee recommendations earlier this year. Why cross-border insolvency is not there so far. But any which ways, I mean, that's fine. It's the government knows best how to do it, and we need to support them. We need to complement. We need to contribute in whatever we can. That is how we just can't be saying this is our suggestion, but we'll just stop at that. We should be submitting our comments by 15th of December, as we all know. Now, I just want to take next 15-20 minutes. I believe I have only 15-20 minutes now more, right?
No, please go ahead.
Yeah, that's all. So I will now just spend 15-20 minutes in talking about couple of things. And I want to talk about Jet Airways. And I want to bring into context also because you mentioned about the judgment of the Bonnet Why. I think it's important. And I'll tell it more in a story way rather than. So when Jet Airways happened, as you know, that the State Bank of India had taken over the management of Jet Airways, the government of the banks had not made up their mind to file insolvency petition against Jet Airways. The promoters of Jet Airways were trying to persuade very hard the bankers to give them some support financially so that they could actually keep the enterprise going, because they thought they will be able to turn it around. In the meantime, in Netherlands, some of the operational creditors filed a petition for liquidation. Now, the Dutch law doesn't have an insolvency, it has a liquidation. And under the Dutch law, if there is a establishment which is the company may not be incorporated in Netherlands or in the jurisdiction of that district court, as long as there was an establishment doing business there, they had jurisdiction. And because Schiphol Airport is where Jet Airways had shifted its regional hub from Belgium, from Brussels Airport, they had a lot of operations there. So an insolvency petition, the liquidation petition was filed, which was allowed. Now, under the Dutch law, if you file an appeal in 45 days, I think, then the appellate court can turn it around if the debt is paid. That is how it is. So when I was hired by the Dutch administrator who was appointed by the court, I immediately advised that you should write a communication to the government of India, to the Indian bankers, and tell them this is what has happened, so that they have an opportunity to prevent any disruption here in India in respect of whatever they might be thinking of doing to Jet Airways. I can talk about it now more freely because we know that ban has been approved in Jet Airways. I have been a little more discreet about talking about Jet Airways, although of course I've been talking to a few people who are taking it up as a case study. Now, letters were written to most of these concerned people in the government, without naming any, including the banks. Personally met and spoke to some. The banks decided that we will not file an appeal, because if we file an appeal and pay that particular creditor, somebody else will come forward and file another petition. We'll have to pay, but there will be an endless exercise. I think this is a fair point. Appeal limitation expired. In the meantime, of course, the Dutch court ordered the attachment of the asset. There was one airport, there was one aircraft parked at the Schiphol airport, and of course, there were certain assets lying there, but there were some employees as well. But there were also, of course, dues as well. State Bank of India, and in the meantime, some operational creditors filed petition against Jet Airways, Section 9. State Bank of India thought that, I believe so, that it will be better if they file the petition under Section 7, because if on Section 9 petition and administrators appointed, it will be a problem for them. And Mamta, you just have to raise your hand to tell me when to stop. Huh? Although I love my voice, but not as much that I'll exceed my time. Okay.
Sure, another 10 minutes, please.
Okay. Yes, I'll wrap it up in 10 minutes. So in Jet Airways, SBI decided to file the petition. When SBI filed the petition, I filed an application on behalf of the Jet administrator in Netherlands, and I went and told the Bombay bench that, look, if you want an insolvency resolution here, you have to find a resolution there as well, because otherwise there'll be a disruption. Even if you have a resolution plan approved in 2 years from now, whenever an aircraft will land in Schiphol, they will seize it because if you don't pay their dues, and they will continue to pass orders. It won't solve any problem. So why don't you reconcile the two proceedings if you're contemplating admission of the Indian proceeding? The honorable bench unfortunately didn't appreciate, and he said, look, how can, in the first place, and that's where he committed the first error. He said, how can when the company is incorporated in India, how can the Dutch court have jurisdiction? Now, first of all, he has no business, and I'm sorry to say that, commenting whether any other court has a jurisdiction or not. You have to see whether I have jurisdiction or not, right? Secondly, he committed another error legally to say that because he came from a civil law background, to say, oh, since CPC says there has to be a reciprocity treaty and you have to file a petition for recognition of that proceeding in India, since there is no framework, that has not been done, I can't recognize. The third thing he said, again an error, he said there's no cross-border insolvency law in India. Legislature has chosen not to pass, so how can I today recognize? I went and appeal against that order, and he said, I'm not recognizing. He appointed an RP, and he told the RP, ignore the proceedings in Netherlands. That was the fourth error. We went and appealed to the appellate tribunal. Appellate tribunal, the first is said, what? And he said, stay. He said, what do you want? I said, this is the cross-border insolvency law. We may not have the legislation in place, but I can assure you this is a perfect case where we can actually apply cross-border principles and we can find a resolution. And he understood that how will we find a resolution if we don't have these two proceedings cooperating with one another? And I suggested that allow us to negotiate a cross-border insolvency protocol between the two countries, which is based on complete mirror image of the cross-border insolvency law, Uncentral model. Word by word, we will do what through protocol, what the law would have provided, otherwise if the law had been in place. He said, okay, go and attempt one. And I have to really give my compliments to Ashish Chaucharia, who was the RP of Jet Airways, and Mr. Rocco Monsor, who was the administrator, my client, all the law firms involved, whether for the COC, for the RP, and the law firm that was also advising him on the Dutch law, and the law firm that was advising on the Dutch law, the RP. 5 firms, and of course, I was advising the administrator. In a matter of 45 days, we were able to negotiate an agreement mutually. Only on 1 or 2 provisions, there was something on which the COC was not agreeable to, on which I put my foot down. COC said, Mr. Rocco Monsor will not attend the COC meetings. And we will not pay his cost as COC costs. And I said, no, he doesn't have a right to vote, obviously, because he is not a COC member. But you can't have a proceeding happening in his back, behind his back and expect cooperation. You have to be completely transparent about it. And when I went to the adjudicate, when the draft went to the appellate tribunal said, we completely agree on both accounts. COC, it will be COC cost, and he will be entitled to COC. Which COC then finally agreed, they did not appeal that order. And we all know that as a Jet Airways judgment, we all know that it has become a landmark judgment. We all know that it has been studied, appreciated. But besides that, what is the most important part is that not only optically it was a great thing, but in real time, as a toolkit, it was used on a daily basis. We were able to sell that aircraft. We were able to get the costs of COC pay, costs of Netherlands administration paid as costs of COC. We were able to attend every COC meeting. We were able to work together, advise on each other. Both the courts cooperated fully and allowed the insolvency resolution process to be passed here flawlessly and the liquidation to close there. It is a remarkable case study where without even a cross-border insolvency law being there. Now, how much of the Jet Airways practical aspects have gone into rule-making process or whatever, I'm not familiar because I'm not part of that. But what the point I'm making is that these practical aspects will need to be, because otherwise the NCLT will continue to struggle with this. One more point that I want to mention before I close, final point, and why I believe that we need to, even if we pass the legislation, unlikely in the winter session, but probably in the budget session, I don't think it should be implemented till the monsoon session. We should spend the 4 months in educating the members of the tribunal. We should hold detailed discussions with them in closed rooms, explain to them so that they're fully up to speed. Otherwise, supposingly a petition is filed for recognition of a cross-border proceeding, a Chapter 11 proceeding, very high scale, in a bench, let's say, I don't want to take a name, let's say, for example, but on a bench where you don't have those kind of high-scale commercial matters on a daily basis, which you'll find in Delhi, Bombay, Ahmedabad, perhaps. There will be a real struggle. And then you'll have to fly in lawyers to come and argue that that's to a cost. We need to make sure that when we go and hit the ground, we are completely ready from that point of view. And I do believe that there's a whole world out there of countries, at least 15 to 20, which is waiting to see what happens in India. Not only by way of how we adopt the law, but how we apply it and implement it. They're fence sitters. They're waiting for India to do it and then before they do it. Of course, from a global narrative point of view, we would still a march over China, which hasn't adopted as yet, right? But China's probably not adopted for about 4 to 5 reasons that I mentioned, right? Because they believe that they need to wait and watch, given the geopolitical economic scenario. All those things are happening at the moment, whether it's time to take leap of faith or not. Now, my last comment would be that yes, we should go ahead. Despite the concerns that I've expressed, they were not to dissuade in any manner the policymakers from not enacting the legislation. I only mentioned that this is a matter which should be referred to the standing or the select committee of the parliament, maybe the joint parliamentary committee. It's a very important issue. And before the joint parliamentary committee, all should be allowed to depose from a geopolitical issue, economic issue, everything as to what are the factors that will wane in the next 4 or 5 years in the implementation of this law. Let the parliament get the benefit of that deliberation. Bring it back to the parliament and then see whether it needs to go into the same format or a different tweaks and introduce it back in the monsoon session. That's what I'd like to say. And Mamta, I'm sorry if I didn't really touch too much about the nuts and bolts of the cross-border insolvency law, but I think there are certain perspectives which are very important to be noted, because these will ultimately come in very handy when we actually start using the law. So I thank you so much, and maybe in the Q&A later on, there are anything I'll talk about more specifically.
Thank you so much. No, that's very, very precious of you to have spoken that, because I think you are exclusively privy to so many things which we would otherwise not have gotten access to. So I think that was very, very valuable. In fact, whenever we read any law, we are absolutely very keen to read the statements of objects and reasons, for the simple reason that we would like to know the background of the law. Because only when you know the background of the law is nothing but an extended logic, what we understand. So when you know the logic and all the nuts and bolts behind it, it is only then we are able to appreciate the law. And in fact, then we also aid in transforming the law. So here, as citizenry, we are not only here to adhere the law, of course, we have to do that. That's our duty, but it's also a responsibility to maybe suggest the government whatever we are facing at the ground level. So whatever that you mentioned, I think everybody of us were on their heels and toes to listen to you very, very carefully. So it was a very precious deliberation, if I may say so. And everybody would actually, if we had the opportunity to clap together, we would have actually put our hands together to say a big thank you to you for taking us behind those eyeballs of yours and so many others who had actually put this piece together.
Thank you so much, Mamta.
So many things goes behind it. So in the word of thanks session, I'll take an exclusive opportunity to do the honors. Let's now move on to Ms. Vanita. You have a daunting task ahead of you, though you are going to tread a different path altogether. You are an academician, but as I know you, Vanita, you've not been an academician alone. You have always been so very having a keen interest in understanding how things transform in reality. And I've also seen you in action a few times in your NUJS, where you've been talking to your pupils, telling them that how execution is also very, very important, that the law is. So Vanita, the field is now all yours. You may take it up as you would like to.
Thank you. Thank you, Mamta. And Suman, thank you so much. You took us on a whole world trip. And if I can just fill in something, the geopolitical warfare that you were speaking about, I think that started or got triggered off in 2008. And it, of course, COVID aggravated it. And somewhere maybe they do not even have the luxury of adopting or even to be seen to be adopting the cross-border insolvency or any other model. Now, coming to what I would like to say, I'll just take us a little bit behind. I'll bring all of us back into our country. And one of the biggest reasons that I want to do it is because I feel that while the legislators are ready, the institutional frameworks are not yet in place. We are still a very highly regulated economy. We are very highly regulated exchange controlled jurisdiction to the extent that we have multifarious bodies which control the foreign exchange, either the inwards or the outwards. On the other hand, we have always had Indian courts who have been very, very proactive in addressing these cross-border issues, and it's not a recent phenomena. Most recent case, of course, has been our Jet Airways case, but even way back in the past, we have had courts which were completely in support of the cross-border insolvency law. There are gaps, and quite possibly these gaps will be filled up by the comprehensive law that we will have in some time. But every other law, like every other law, it is as good as the people who want to implement it. And as I tell my students, having a law doesn't always mean that you have to apply it. You also have to know when not to apply it. At the end of the day, our insolvency law revolves around business and business practices. As with any other good business practices, it's best to step away from lawyers and the legal minefields and to execute it the best way. One of the biggest reasons why Jet Airways has become a model judgment is perhaps because it was not executed just by lawyers or by the judiciary, but by a consensual agreement between the business and guided by the lawyers in the drafting part. Now, this supporting infrastructure is something that will make or break our cross-border regulations. The protocols are very, very instrumental for the parties to come into the framework for a resolution. Without having a good protocol, it's very difficult to get all the parties on the board at the same time. A judicial recognition helps. A judicial recognition helps. A protocol, well-drafted protocol helps. Exercise of rights is something that is usually laid out in the protocols. So once a protocol is drafted, maybe the courts would approve it and enforce it. But beyond it, the court's role is not, I do not foresee a very huge role for the judiciary with regard to cross-border. Now, just going back into history a little bit, just stepping into the history. So way back in 1908, we had cases where the businesses indulge in this cross-border insolvency. This was your High Court of Madras that dealt with it. Then we had the very famous the Raja Vijayanagaram case, which has been a case study all through, wherein the courts, actually the Supreme Court stepped in and said that no, they do have a right, the foreign creditors do have a right to get their claims in India. This was under the old Companies Act. So even though the company incorporated in India rejected the foreign creditors' claim, the Supreme Court very clearly said no, they do have a right. And of course, we have had the recent Videocon case, we have had the Jet Airways case. In each one of these cases, what you would find consistently is you would find that the courts, particularly the High Court and the Supreme Court, who have extensively laid down very clearly that the foreign creditors have a right of say in the Indian action, be it of resolution or winding up. So development of a cross-border protocol, how far will it be feasible based upon the law once it's drafted, is something that only time will tell us. However, I do feel that it should be flexible enough to incorporate or allow incorporation of foreign elements, and yet it should be rigid enough to give us a definitive support service wherein you know that, well, this is the parameters in within which you would have to work. At the same time, just amending IBC or including cross-border will not be sufficient unless we make proactive amendments to the ancillary laws around it and to the permissions or to the regulatory changes that we are looking into. So yeah, cross-border insolvency is something that I'm looking forward to. I have been looking forward to for quite some time now, primarily because it gives me a good academic material for discussion. But even otherwise, I do believe as an individual that a business is best left to businessman rather than the courts and the judiciary or the legal systems. Same thing holds, in my opinion, for insolvency as well. The best resolution plans are the ones that are drafted by the business themselves. And somewhere, yes, I do have a hesitation with the 29A, because I do feel that it is directly in conflict somewhere with your 12A. But that's, again, my personal opinion on that. And yeah, so this is where I stand with regard to cross-border and the judiciary, and my position on the judiciary with regard to cross-border as well. So Mamta, I think it's best I close here. I don't really have much to add after what Sumant has said. Over to you, Mamta.
Sure. Thank you, Vanita. I think thank you so much, because you actually gave us a breather by having some space of time for some valuable questions, because we have the presence of all of us here. We have Mr. Chandyok, and we also still have the presence of Sumant, who, in spite of being on holidays, with us continuously. So we can actually have the floor open for a few questions. Anyone who would like to have any questions may just raise your hand, or we'll request ACA to actually unmute yourself. We can have at least 4 questions, and the others you may put it on the chat box. We can come back to you on a later date.
Mamta ji, there are some questions on the chat box. Can we read that?
Yes, I'll take it up. So they are quite global questions. What will be the challenges of cross-border? What will be the challenges of cross-border insolvency law in dealing with avoidance transaction? Who would like to take this? I don't think actually avoidance transaction will really come in the sense that we look at it today in the insolvency law, because cross-border insolvency will be for very specific purposes. Maybe probably to take charge of the asset which is offshore, or to take an asset here would not mean only an asset which you're able to see and feel. It could be a debtor, it could be an onerous transaction which is also pledged, could be. So even those will come in as a cross-border insolvency, not in the right sense that we deal in today as an avoidance transaction. We'll have to see how it unfolds itself, but that's an immediate thought that came to me. If anyone have any other views, then you kindly add up.
Yeah, I believe that it will be part of the protocols that would be put in place right at the inception. Whenever we are having a cross-border, like Jet Airways, they had an agreement, a consensual protocol put into place. What they did not have is they did not have the framework of law to go along with. But I don't think they did anything that would not have been already in the framework of law. So any such criminal actions, I think that is what my VC also wanted to say, any such criminal actions would be part of the proceedings of the law of the land, and they would have to take its own recourse. And there will always be a clause in the protocol which would enable it.
Okay.
We have
Thank
already
you.
seen that happening with us when we saw that some brings matter, and with all that we saw whether you're prosecuted in Italy or you're prosecuted in India.
Yes.
So India does not, for an Indian to do an offense in foreign country, I can still be tried in India. But a foreigner doing an offense will have to be tried in that country under the laws of that country. It cannot be part of the insolvency in that sense of the matter.
No, sir, we have seen this with the PMLA and our Economic Offenders Act as well. So this with antecedent transactions or any other transactions, this clawing back would be, I think, would be part of the insolvency protocol itself.
No, I'm only answering that criminal action. The criminal action
Yes.
would have to be there.
The
Flowing back
prosecution
would
part,
be-
the prosecution part.
Yeah, prosecution part would be there.
Yeah.
It could be that whatever he has benefited out of it may come back to the kitty
Yes.
of the resolution. That's a different matter.
Thank you. So Suman, there's a specific question which is being asked from you. I would like to hear you on one fundamental point, Suman sir, that is CPC recognizes judgments of foreign courts with few excepts as per section 13 of the code. And section 44A of CPC provides for execution, just give me a minute, provides for execution of foreign decree with conditions of superior court and reciprocating countries. Why is it then that India needs a separate law on cross-border insolvency? It's there in the chat box also, Sumant, if you would like to just access it to have a better purview of it.
You're on mute, Sumant. Yeah.
Yeah,
Yes, sir.
Sumant.
Mamta, you'll have to repeat it for me because I'm sorry, I was distracted. I had to take a call. So if you don't mind, please can you repeat it for me?
No, not at all. Sumant sir, I would like to hear you on one fundamental point. CPC recognizes judgments of foreign courts with few excepts as per section 13 of the code. And section 44A of CPC provides for execution of foreign decree with conditions of superior court and reciprocating countries. Why is it that India now needs a separate law on cross-border?
Yeah, so I understand. Thank you so much for asking this question, because section 13 and 44 do not apply. There for a judgment to be recognized, it should be, first of all, it should be not an interim order, it should be a final order, it should be passed on merits. It should not be also, it should be from the same judgment, which is equivalent of the judgment of the court in which the application for recognition is brought in. And also, you need to have a reciprocal territory with the country from which this petition is filed. There are so many restrictions and constraints in that. While in an insolvency petition, actually, you need recognition as of like yesterday. And you can't have, and it could be an interim against an interim order. In fact, that could relieve the trigger point. You may need an interim order without even a recognition having been made. You may even need a substantive order, even though you have not determined whether this is an order that has been passed on merits or without hearing or whatever. The only test that need to be satisfied is that the foreign representative who's filing the petition for recognition, he should give a declaration that it is from the competent court. An English translation of that has to be filed. And there is an assumption that is in law, inbuilt into law, that once this is done, it is deemed that it has come from a competent court and the person who's filing it is competent to and authorized to file. Because in insolvency, you need speed. You don't have the luxury of time where somebody files an application, somebody opposes, on various grounds, technical grounds, and before it is taken up. The only one exception which is there, which of course is there even in the 30 and 44A, is it should not be against the public policy of India. Yes. That is something which even the cross-border insolvency, allows as one exception to recognition. So you can refuse it on the ground that if the recognition would be against the public policy of India. And that is exactly why it has been recommended all through, including by the JPC in 2016, that we need a framework, comprehensive framework. And not only because CPC would be Like, once you have, you have not even recognized, your hands are tied, what reliefs you can give under secrecy, what you cannot give is all codified. While in insolvency, you can give a relief under Section 14, because once the recognition takes place, then the jurisdiction that is to be exercised on the proceeding that is recognized is as per the Insolvency and Bankruptcy Code, which means that you can pass any order of moratorium, you can grant all other reliefs that you can grant, whether under Section 19 or otherwise, which will not be available. Because so you have to first go to the civil court to get recognition, then come to the IBC. So that is not feasible. That will defeat the very purpose.
Thank you so much. There's another question that's come up, that why is India always so hesitant to adopt the Uncentral model? I don't know.
So I can tell you from whatever little interaction that I have had, the initially, and very rightly so, the government felt that, if you don't have a sound domestic insolvency law, why would you even want to bother to have a cross-border law? It'll be, why do you want to expose your country to people coming from sophisticated organized countries and see that in India, the domestic law is so fragmented, is not up to speed, is not, something which is even fair and modern and sophisticated enough. So that weight was fully justified. Subsequently, when the IBC law was being proposed, Bankruptcy Law Reforms Committee in its own wisdom felt that we have too much on our hands as a task as a country. We need to first of all put IBC on its feet, and then let's see, we do cross-border in the second phase. So they decided, let's do it in 2 phases. Even the personal insolvency law has not been implemented so far, because the government felt that you need to have insolvency, corporate insolvency. That's a fair point. But on the cross-border insolvency, my complaint is not that why it's not implemented in 2016. My complaint is that it should have come in 2017 or 2018 also. Because while those companies, big accounts, 30 were still going through that stage where resolution plan were being received or considered, we could have benefited from the cross-border insolvency law, and probably the lenders could have got a higher value than what we eventually did.
Thank you. Thank you so much. I think Mr. Velamur Anand, very senior professional, is wanting to say something.
Yeah,
Mr.
thank you, Mamta.
Yes.
I just wanted to put this to one. See, for avoidance transactions, Article 23 of the model law allows the foreign representative also to file for the avoidance and also to seek an order to reverse the transaction. So, is that correct? So there is a provision for avoidance. Will that be incorporated in the amendment that is now being proposed in India?
Yes. So the very principle of cross-border insolvency is, since it has been recognized, the foreign proceeding has been recognized, and whether if it has been recognized as a main proceeding, then India has to complement it, support that main proceeding. But if India is recognized as a main proceeding and the foreign proceeding is a non-main proceeding, then the foreign representative is allowed to take reliefs from India, any such relief that any creditor would be entitled to. But he can't file it as a foreign representative, because that in Indian main proceeding, only an IP can file, the Indian resolution professional can file the proceeding. So it will depend on whether it is India is the main proceeding or non-main proceeding. To answer your question, if India is the main proceeding, then only the RP can file. If India is a non-main proceeding, then the foreign representative of the main proceeding can file an avoidance petition in India.
I think a lot is to be done with COMI, the fact that the center of main interest. And if we see the model part Z, it also mentions that sometimes it will be left to the court also, if there is a too much fragmented views coming in about COMI too.
So if I can just take 2 minutes on COMI.
Sure.
In fact, because I got a little swayed and I spent too much time on my, the background context.
Perfect.
I wanted to actually speak on COMI for a couple of minutes then, but I'll just be very, very brief. The COMI is something which always will create a lot of anxiety for any jurisdiction, because no court would want its jurisdiction to be ceded to another jurisdiction, right? And they would also want that the stakeholders which are in their jurisdiction, they should not in any manner get compromised. It's a very fair thing. But cross-border insolvency framework has gone through all this when the global community debated, of which incidentally I was a part of over 7-8 years, and it has been evolving over a period of time. And there is a crystal clear view on the commie now. Most sophisticated economies like UK, US, Australia, Canada have provided very clear views on this. There are cases where US has allowed Canadian courts to be main proceedings, even though a large part of business was in US, a lot of employees were there, large number of lenders were in US, because they felt that even though that a lot of activity was taking place in US, but it was Canada where the center of main interest was, because the financial restructuring, the economic restructuring should be best be held in Canada, not in India. So for example, in India, if Ford has 5 plants in India, hypothetically, to make cars, but it is Singapore which is their like economic headquarters. That is where the lenders have invested. That is where the lenders sit. That is where the trading and the stock exchange is taking place. They may be Indian lenders. The activity may be taking place in Chennai, Manesar, or elsewhere. But the operational restructuring may take place in India. But the financial restructuring will happen only in Singapore by the lenders sitting there. If they are not okay, then how will the operational restructuring take place? Then you could also have even Singapore as a drop-down subsidiary of a US company, and coming through Mauritius, there could be 5-6 jurisdictions, but ultimately the key lenders who take decisions or who will take decisions, whose decision matters, if they sit in Mauritius or if they sit in US, then that's where it should take place. Just because you have 5 plants for in a global conglomerate, they will have production units across the globe. You can't have that restructuring happening across the globe. It will happen at the end of the day in one main proceeding where you will know that lenders sitting there are the right stakeholders to take a decision. But yes, cross-border insolvency will make sure that the domestic laws of each country are protected. So for example, in India under Section 53 waterfall, if the employees have to get along paru passu along with the secured creditors 14 months or 12 months or 24 months for workmen's salaries, that has to be honored even by the foreign court while making payments. That you have to do. Otherwise, nobody will ever give a recognition.
Yes, thank you, Sumant. In fact, it's time that we actually wind up. But just to say, everyone, that we are seeing what Sumant had just mentioned, that even IBC, the Indian law, has to catch up to its speed. Now, in the name of audi alterum partem, that is, of course, the principles of natural justice, we see that time and again, so many issues just get so much of time and bandwidth of the court every day. Sometimes we see that the respondents or the interveners even just come with a letter in their hand, and at times we feel, at least I'm sure it's not the way it is projected, but even a single letter gets hijacks the proceedings of the tribunal or the adjudicating authority, as it may be called. In one of the recent NCLAT judgment we saw, and that dealt with cross-border insolvency, if I recollect, it said that adjudicating authority is neither a court nor a tribunal. So therefore, it went on to mention that there were some proceedings which were on, some case law which was being appealed, some case which was being appealed against, and in that which had some cross-border elements too. So we don't know what to, should we call it a tribunal or should we not? Let's stick to the point of adjudicating authority. So we have actually been quite pained, and we are struggling in the courts to even talk about the 330-day deadline that even the Honorable Apex Court has put on us. Let's see how it spans out. I'm sure after this colloquium very recently, which had been held, we are seeing quite a lot of change in the mindset also, and I'm sure going forward things will catch up speed. With that hope, we also resonate to what Mr. Batra mentioned, to say that even if this gets listed as a law for us to follow, it should not be done in a hurry and scurry, because it should be given some time as a breather, somebody who actually has to execute it, and that is, we're talking about the adjudicating authorities and the appellate bodies. I think it's very important, even for us for that matter, because law is as good as it is executed. So we are the frontliners. We are the ones who will be having the axe in the hand and the spade in the hand to actually execute it. So it's very important that such programs and lecture sessions, bilateral, or should not be a monologue, as we did not have a monologue today also. It's important at times also that we need to understand what's behind such a law. It helps us to execute it better. It helps us to strengthen the eyes and the ears of the adjudicating authority also. So let's see how the government takes it up. But one thing is for sure, we just cannot be sitting tight-lipped. We should make sure that our voice is actually sent to the corridors, who is actually going to take up these papers towards making it a law. It's high time that we should actually maybe put together our thoughts in a piece of paper. We should elucidate that better and make sure that it reaches the tables which matters. And these programs are definitely a supporting ones. A very, very big thank you to all our esteemed speakers and the guest of honor who but could not make it. The Vice Chancellor has sent us a paper that he wanted me to share to everyone. Because of the paucity of time, I could not read it, but it's very, very invaluable. It contains a lot of information which otherwise would take about maybe 4 to 5 days to get it synchronized in 3 sheets of document. I'll circulate it to IBC Laws, who will in turn circulate to all the people who have attended the program. I don't know whether this is appropriate or not, but let me just take 2 minutes beyond the time, because this will be precious and important to all the guests who have come in and to all the people who have attended the program. You know, it so happened in a very, very sunny afternoon that a person was doing some sketching in Poland. I choose that land, Poland, for this example. So this person was doing some beautiful sketching. So Mr. Vivek was going through that place and he was very intrigued to see what's happening, because there was so much of rush and people were spellboundedly looking at that single gentleman. So Vivek couldn't stop himself and he went inside and he saw that, oh, that gentleman was doing some beautiful sketches with pencil. And the person who was sitting right in front of that man, of whose sketch he was drawing, when he saw and matched both of it, he saw that it was absolutely a replica. Even the fine lines of the eyes were very, very well captured. So Vivek could not stop himself and said, hey, gentlemen, after you are done with this, would you draw my sketch too? Obviously, that man's job was to draw sketches. So he told Vivek, okay, Vivek, just be on a hold for some time. Let me finish this and then it'll be your turn. So when Vivek actually got his turn and he sat, that's okay, the sketch was drawn. And it was drawn in flat 3 minutes. So Vivek was quite surprised and said, oh, that's nice. You know, I saved my time. So Vivek said, okay, gentlemen, how much do I pay you for this? So the gentleman said 300 pounds. And Vivek like, oh God, for a 3-minute sketch, this gentleman is asking 300 pounds, and he fell off the sky. But, you know, he was in a foreign land, probably cross-border insolvency had not come by then. So Uncentral, he could not take access to. And he was very scared. He said, what to do now? I'm in a foreign land. I have to just give it away. So very hesitatingly, then after giving the money, he asked, why did you charge 300 pounds for that 3 minutes of work that you put in? So, you know, the answer is very, very interesting, and you may tie your seat belts to listen to this. That gentleman said, hey, I did this in 3 minutes, and the charging that I'm doing this is for that 30 years of experience that I have put in to make this sketch in flat 3 minutes. So that's how it is, Vivek, and you had to pay that, but you were very, you know, you were then not very disinterested to pay that money. Today's session, I think, by having Sumant, by having Chandyokji, and of course you, Vanita, and by having NUJS and the other organizations, we actually displayed insightfully that how important it is when people have actually lived the law. When they talk about the law, it is very different when people who have just not even sipped it through in a cup of coffee would actually talk about it. So thanks a ton to each one of you. And from ACAE and all of us, we put our hands together in sharing e-mementos that we have built up. I don't know whether you're able to see or not. So this is for Sumant. Sumant, you're able to see this?
Perfect.
Yes, I can. And thank you so much for this.
Thank you, Sumant. So this, I'll send it over to you on the email also.
Thank you.
And very quickly, I'll do that for Vanita too. Vanita, not able to see this? Are you? No? Okay. I think I'll again have to do a stop share and just give me a moment. Yeah. Okay.
Mamta ji, let me do for you.
No, wait. Otherwise, I'll look like a novice. Let me do this. Is it there now? Is it there now?
Perfect.
Okay. Thanks, Vanita, for being with us. And we'll definitely send the professor's memento to you too for the onward sharing. Thank you, Tan, and for this
And
beautiful.
I will thank the moderator as well.
Mamta,
Thank you,
just wanted
madam.
to mention that I have emailed you my presentation, which you may want to share with it.
Yes, we would love
And we also thank Mamta ji for coordinating and moderating
Thank
this
you,
session.
Mamta ji, for
Would not be
moderating
possible
the
without
session.
her, because she was acting like a Sarathi who just connected all the dots, all the organization, and getting Suman sir and Vinita ma'am for this wonderful Sunday morning. And I would like to also add over here that with the flow with which she conducts the session, we all get stumped and we all get connected to the session. And moreover, Mamta ji touched on a very valuable aspect. I also face actually such things in my life. When people come for an India's balance sheet, it takes only 10 minutes to make. Why you charge so much? I said, we learned for 10 years to make this 10 minutes balance sheet. That was a very good correction for the, we all professionals, we should value our service. We should value our service. Thank you, Mamta ji. And
Thank you, everyone.
Thank
Thank
you.
you, everybody.
Thank you, Mamta.
Have a
Bye-bye.
very good Sunday. Thank
Have a
you.
great Sunday.
Bye. Sanjay sir, thank you for being with
Thank
us.
you
also.
so much. Thank you so much.
Thank
Thank you,
you so much.
Suman. Thank you so much.
Thank you so much, sir.
Thank you.
Thank you so much.
Thank you to each one of your esteemed participants. It wouldn't have been possible without you. Keep coming.